Judgment in the matter of Davies against the Bridgend County Borough Council.
Lord Stevens will hand down this judgment. This appeal, brought by Bridgend County Borough Council, raises an important question in relation to the causation of recoverable damage in the civil realm of private nuisance. In general terms, private nuisance is committed where the defendant unduly interferes with the enjoyment or use of another person's land. In this case, the nuisance arises from the encroachment of Japanese knotweed from land in Bridgend owned by the defendant, Bridgend County Borough Council. The encroachment was onto adjoining land owned by the claimant, Mr. Davies. The initial encroachment occurred at some date before 2004. However, in 2004, encroachment of Japanese knotweed onto neighbouring land was not an actionable private nuisance. An actionable private nuisance first arose in 2013, when the defendant was, or ought to have been, aware of the risk of damage and loss of amenity to the claimant's land as a result of publicly available information about Japanese knotweed at the time, and it failed to implement a reasonable and effective treatment program in relation to Japanese knotweed, which it knew or ought to have known was growing on its land. It was not until 2018 that the defendant implemented a reasonable and effective treatment program. Accordingly, the lower courts found that there was a continuing nuisance committed by the defendant in failing to effectively treat Japanese knotweed on its land between 2013 and 2018. In 2020, the claimant brought proceedings seeking damages for the defendant's breach of duty and private nuisance. At trial, the claimant sought to recover £4,900 as damages for the residual diminution in value of his land. This was said to represent the loss in value of his land that would exist even after the effective treatment of Japanese knotweed on his land. The evidence presented at trial was that Japanese knotweed can be treated but not eradicated. Even after treatment, there would remain rhizomes of Japanese knotweed in the soil of the claimant's land, which, if disturbed, could lead to the Japanese knotweed regrowing. Accordingly, the value of the claimant's land was diminished as it was adversely affected by stigma in the property market, which stigma was fueled by media articles and internet discussion. At trial, the defendant submitted that the claim for residual diminution in value was fatally flawed, as any residual diminution was caused by the non-actionable presence of Japanese knotweed on the claimant's land, which occurred before 2004, and therefore before the defendant's breach, which commenced in 2013. The district judge rejected the defendant's submission and held that the diminution in value was caused by the continuing breach of duty between 2013 and 2018. However, the district judge declined to make an award as he considered that the Court of Appeal's judgment in Williams against Network Rail precluded any award for diminution in value. On appeal, the circuit judge also considered that the diminution in value was caused by the defendant's actionable nuisance, but relying on Williams against Network Rail, upheld the district judge's finding that the claim for diminution in value was irrecoverable. On a second appeal, the Court of Appeal held that the district judge and the circuit judge had misunderstood the decision in Williams against Network Rail. Both the district judge and the circuit judge were incorrect to hold that in the circumstances of this case, diminution in value was not recoverable. The Court of Appeal then considered whether the diminution in value was caused by the defendant's actionable breach of duty. The Court of Appeal, relying on the decision of the House of Lords in Delaware Mansions Limited against Westminster City Council, Delaware, found that causation had been established and made an award of £4,900 for diminution in value of the claimant's land. The defendant now appeals to the Supreme Court, contending that the diminution in value occurred prior to and was not caused by the actionable private nuisance. The Supreme Court unanimously allows the appeal for reasons set out in a judgment given by me, with which the other justices agree. Lord Burrows gives a concurring judgment. I will now briefly summarize the reasons. In the tort of private nuisance involving encroachment of Japanese knotweed from the defendant's land onto the claimant's land, the claimant is required to establish that the defendant's breach of duty did in fact cause the loss suffered. The decision of the House of Lords in Delaware, which was relied on by the Court of Appeal, is authority for the proposition that a claimant, in certain circumstances, is entitled to recover the reasonable costs incurred in taking steps to end or to lessen a nuisance. In other words, to recover the reasonable costs incurred in abating a nuisance. A loss representing a diminution in value is not an aspect of reasonable costs incurred in abating a nuisance. Accordingly, it was incorrect for the Court of Appeal to rely on Delaware to make an award in favor of the claimant for diminution in value. Rather, in considering causation in this case, the but-for test should be applied. The purpose of the but-for test is to eliminate irrelevant causative factors. In the context of this case, the but-for test asks, would the diminution in value of which the claimant complains have occurred but for the breach of duty of the defendant between 2013 and 2018? If the diminution in value would have occurred in any event, then the defendant's breach of duty is eliminated as a cause of the diminution in value, so that there would be no causal link between the defendant's breach of duty and the diminution in value of the claimant's land. The answer to the but-for question in this case is to be seen in the context that there was no evidence before and no finding by the district judge that the defendant's breach of duty between 2013 and 2018 had increased or materially contributed to the diminution in value of the claimant's land. In that context, the answer to the but-for question is simply that the diminution in value had occurred long before any breach by the defendant of the relevant duty in private nuisance first occurred in 2013. Accordingly, the application of the but-for test in this case eliminates the defendant's subsequent breach of duty as a causative factor. There is no causal link between the defendant's breach of duty and the diminution in value claimed. Accordingly, on the application of the but-for test, the appeal should be allowed, so that no damages are awarded. The claimant also sought to support the award made by the Court of Appeal on an alternative basis. It is sufficient to say that the alternative basis was not pleaded, there was no evidence to support it, let alone was there any discharge of the claimant's burden of proof. On that basis, it is rejected, and the position remains that the appeal should be allowed. In conclusion, the appeal is allowed.
The court will now adjourn. Memory.